I'm going to invite Sean. Let's give him a hand of applause. Come here. He flew all the way from Texas to just be here with you to teach you this event. Isn't that amazing?
Thank you. I'm looking forward to it. Thank you, everybody. Let's see if I can get this set up properly here. Just out of curiosity, I want to get a feel for the room. Who's here because they're an investor or wants to invest in a project? Anybody with a company or potentially looking to raise money through crowdfunding? Okay. Any other categories? Anybody I missed?
Portal developers.
Okay. Look at a portal. Crowdfunding portal?
Yes, equity crowdfunding.
Just a service provider, education.
Service provider. Okay. Yeah, you were interested in the educational aspect of it, right? Okay. I'd like to make it interactive, so please feel free as we're going through. If you have questions or thoughts or ideas, I want to tailor this to you. So we've got prepared remarks. We'll sort of go through the different exempt offerings, hitting different ones that people will see. But if you have questions or ideas, please let me know, and we can build those in. Educational, I'm not giving anybody any specific legal advice for your situation. That will be done separately with whoever your chosen attorney is. This is who I am, just a little background on me. We are a corporate and securities law boutique. We work with a variety of clients, usually businesses and business owners, working through a variety of issues. Offices in Dallas and New York. I come back and forth to New York several times a year. We also have a person here in New York City. I've spent 12 years practicing corporate and securities law, a couple of the largest law firms in the country. And like I say, our firm is focused on businesses and business owners and how they raise capital and meet other objectives. So tonight we'll go through the basic concepts of what is securities law, how it works, and we'll look at the commonly used exemptions that we see in practice. These are not all the exemptions that might be available. In a minute we'll talk about what an exemption is and why it's important for those that may not be familiar. And then I'll have some time for question and answer. To the extent that people don't have questions during the presentation, we can do Q&A later. All right, so what is a security? We talked earlier about the Howry test, which is the Supreme Court ruling. But securities are very broadly defined. So we'll talk about that. We'll talk about the difference between registration or exemption, what an accredited investor is and why that's important, and what general solicitation is and advertising and why that's important. And here you see a definition of security pulled from the Securities Act, but it's essentially a very broad definition. Anytime you're buying an interest in a company that's tied to the performance of that company and its profitability, you're probably falling into the definition of a security. If it's a piece of property, it may not be a security. Real estate gets very gray. Sometimes real estate is defined as a security, sometimes it's defined as property. It really depends on the facts and circumstances of what that piece of real estate is and how it's being managed. State laws have similar definitions to federal. Basically, anytime you're selling equity or ownership, you need to stop and say, is this a security? You'll likely find in your analysis that you are selling a security. A lot of early stage companies go out and raise money. Don't think about this. There's a mistaken belief that there's a friends and family exemption, which when we talk about the exemptions in a bit, there's no specific definition for friends and family. No specific exemption for friends and family. So just because you're doing a small round or a small company doesn't mean you're exempt from securities law. And why does this become important? It becomes important if you're challenged by an investor, because the smart lawyer will then go back and point to the securities law as a way to try to get that investor's money back from the company. And not only back from the company, but also back from the officers. What they'll often allege is that the officers made personal representations about the company. So the business owner is out meeting with some potential investors, talking about how great the company is, how it's going to perform. A smart securities lawyer representing an investor will often come back and say, oh yes, the officer or owner of the company made representations on behalf of the company. Therefore, not only can I go after the company for the money back, but I can also go after the officer. So something to be very, very alert of. So always stop, say, is this a security, and am I compliant? Regulators also pursue it. So not only do you have the securities lawyers or the plaintiffs' lawyers that are representing investors that may come after somebody, but also you have the regulators. No specific exemption for small businesses. These regulation actions come on both the state and the federal level. We see both the SEC and the state securities commissions doing these. And sometimes the regulators will direct actions at smaller issuers. A lot of people think because they're busy and they don't have the resources, they may not come after a small offering, a nominal amount, but they're often used as test cases and to set precedent. So you find a small issuer who violated securities law, and then you can use that for case law to go after other security law violations. So just because somebody's small doesn't mean you have it, you're safe. So registration and exemption. Under federal law, you either have to be registered or exempt. So you have two categories in the world. Registration is usually very onerous, requires meeting various SEC requirements, preparing detailed financial statements, disclosure documents, which can be quite lengthy. Your other option is exemption. So you find a way that you don't have to comply with the registration requirements under securities law. So when you're looking at your documents, you probably almost always in a private, smaller deal, you want to go with the exemption route. The registration route is usually just way too expensive for most cases. You can also register under state law. We'll talk a little bit about that and why you might want to do that later. But a registration system typically has minimal disclosures, minimal documents, that has kind of a formulaic, you must tell investors about this, this, and that. So the SEC has laid out a variety of exemptions that they offer, and we'll start talking about some of those exemptions. These are conditional tests that have been set up by the SEC that say, if you meet these conditions, we will not require you to register. They're still subject to some of the anti-fraud and other requirements. So there's reasons why even if you're exempt, you're going to want to have a written document. Yes, Alex?
Yeah, register, you mean IPO?
No, not necessarily. Registration can be broader than that. So if you're not in an exemption, which we're going to run through the various exemptions, then you typically have to register with the SEC, which doesn't necessarily mean you're doing a full-blown IPO. If you don't get an exemption or you misstep on your exemption, then you're required to register with the SEC. So you may end up in a situation where you have a company that's registered with the SEC but hasn't even done a full IPO, doesn't have publicly trading stock, and that's kind of the worst case scenario you want to end up in. So you always are trying to avoid that. Similarly with states, you may have to register. We'll talk a little bit about Reg A and Reg A Plus later, but those systems also may require registration with the state. So now you're filing documents with the state is reviewing those documents and going over them before you can finish your investment. So registration simply means that you're providing those documents and putting them on file with either the SEC or the state, whatever the case may be. Sometimes it's both.
Typically, how much would it cost to register?
Really depends on the company, depends on it's not cheap, let's put it that way. Depends on the company, depends on how good your current existing business plan is, depends on where your financials are.
Is there like an order of magnitude or range or?
Yeah, you're not going to be able to. You're not going to register for less than $20,000 or $30,000 in legal fees. There's no way, and that's the low end. And it can get into 100, 200, 300,000. IPOs can easily exceed that. Plus, you'll have accounting fees and other professional fees associated with that. So it's not an inexpensive proposition. Usually, your much cheaper option is to find an exemption. So that's why it's so important when we're talking now about registered versus exempt. For most smaller offerings, you're going to want an exemption. There's going to be rare cases where you're going to say the easier route is to register. And a lot of the definitions in these exemptions are tied to accredited investor status. So we're going to talk about more. We're going to work into the exemptions here in a minute, but it's going to be important to understand as a foundational concept who is an accredited investor. Generally, these are people that are financially larger. So the SEC and the states following suit have said, if somebody's of a certain financial size or stature, we're going to allow them to participate in these exempt offerings. So these are people that either have great resources, some banks and large buyers, people that have great information, directors, officers, control persons of the company, and people who have wealth. So $1 million individual net worth, now excluding their home. A couple of years ago, that change was made, so now you exclude the primary home of the investor in their net worth. So it has to be over $1 million in assets outside the home, or an income of $200,000 for one person, or $300,000 of two spouses. So basically, these people, either because of their experience, their knowledge, their assets, they should theoretically be able to fend for themselves. And there's some talk about upping these numbers, but these are the numbers we're at right now. Another key concept to talk about is general solicitation and advertising. So a lot of the exemptions are tied to a lack of general solicitation or advertising. So most of the exemptions you're going to see will say you cannot generally solicit, you cannot advertise. So this means basically you can't be running around telling everybody. You can't be handing out flyers to people you don't know. They really want it to be a control group of people that you do know and that you have a pre-existing relationship with. You had a question about
I just want to bring up, when you talk about general solicitation,
Yes.
that even something that someone would do inadvertently, like do a news story, and a newspaper reporter puts in the story that the company is raising money,
Yes.
can blow something like that. So
It can.
if
Yes.
someone's launching a business, they have to be careful.
Right.
Everyone they talk to, they have to be careful about that.
Very careful. Yeah. And if we're working with clients that are doing that type of activity, we often want them to keep a register, a ledger of who they're talking to and what they're talking about. And it becomes quite onerous because it can be something as simple as that. Somebody says that, or you present to an audience about your product, and you mention we're raising money. Well, you may now have done a general solicitation inadvertently. You weren't there to raise money, but word gets out in the room that you are raising money. You've possibly done a general solicitation, and that will cause a lot of these exemptions to not be available. And another thing to keep in mind when you're doing these security law exemptions, the onus is on the company or the person using the exemption to prove that the exemption's there. So if an examiner shows up from the state or the federal government and says, we think you did an unregistered offering and you don't have an available exemption, it's your job to go back and prove up that the exemption was there and to work through. Each of these exemptions have various bullet points or conditions you have to meet. You're going to be proving that you met the conditions. So in these general solicitation situations, you have to prove that you didn't do a general solicitation. The burden's on you. So these are the commonly used exemptions. Rule 506, which has been a long-used, very popular exemption. 506 has now been split into two parts, 506B and 506C. So to the extent you see if you see older articles talking about 506, that's 506B. Now there's 506B and 506C. We'll talk about the difference between the two of them in a little bit. The Crowdfunding Act, we'll talk briefly about that. There's no final regs on Crowdfunding Act, so from the equity side of crowdfunding, it's still not permitted under the law, at least on a federal level. Talk about Regulation A, which is a long-standing exemption, which has been very sparsely utilized. And then we'll talk about Reg A+, which is about to go live, and people expect we may see more usage of A+. So out of the room, and most people have familiarity with all of these exemptions, or is this new territory? Yes.
I have a question about 504, Rule 504 and 505. Is that something that is kind of being phased out, or are fewer people using those?
Yeah, 504 and 505 are still available. 506 has largely outnumbered it, and we know because a lot of these require, the Reg D requirements require people file a Form D with the SEC.
Right.
And then they also typically have to file with state. So we have some data on who uses what. And it's about 90% 506 in recent years. 504 and 505 are also Reg D exemptions, but they're not utilized as much. And 504 and 505 often have a state filing requirement, which is one of the reasons people have run to 506. 506 preempts state law. So you have a dual system of regulation, right? You have federal and state, and they overlap each other. In some cases, the federal government has said, if you use our exemption, such as 506, you don't have to comply with state. You may have to notify the state that you used it, but you don't necessarily have to comply with state of the states where your investors are in. 504 and 505 don't have that same provision, so people don't use them as much because of the state filing.
Popular as it used to be.
Yeah, you want to just file as little paperwork as you can, and 506 has gotten pretty broad with the way it's been interpreted and defined, so it's very popular.
Oh. So is that kind of considered like federally covered?
Yes. So, yeah, the federal law, what they say, preempts the state law. So the federal law says if you comply with our federal exemptions, you don't have to comply with the state. So, it becomes very popular. So, yeah, 506 has been 90% of the exempt offerings. They're conditional exemptions. You must comply with the exemptions in order to have it. So they list it out, and you have to check off each box of 506. 506 has now been split into two parts. 506B, which is the old 506. Anything you read about 506 from a couple of years ago, that's a 506B offering. That's your traditional, what most people are familiar with. And the new 506C, which is very interesting because it allows general solicitation if you limit yourself to only accredited investors. Alex?
Yeah. So in the Silicon Valley, when you go to a venture capitalist or raise money, they're using 506B.
Very common, yes. Yeah, that's typically it. I mean, 506 has become so common, it's almost the go-to. As long as you keep it private, no general solicitation. And because the way the rules work, you're generally going to keep a 506 only to accredited investors. So if you do that, no general solicitation, accredited investors only, you're usually going to go into a 506B. It's there.
You need up to 10 unaccredited, right?
Up to 35 non-accredited. The issue with non-accredited is, and we'll talk about it in a minute, is as soon as you bring in one non-accredited investor, then your information requirements greatly increase. So you essentially have to do a longer private placement memo or securities document, and it's the existence of one non-accredited investor that causes that. So we'll see a lot of times people will not want to bring in non-accredited investors into a 506 offering because the information requirements become so great and onerous. Here's the major check boxes for a 506. No general solicitation or advertising, so you're only going to people you know and have a pre-existing relationship with. Unlimited number of non-accredited investors, up to 35 non-accredited investors. So the way the rule's written, it's interesting, but the way it's been interpreted is that's it. Unlimited, accredited, 35 non-accredited. If you read the rule on its face, it's not quite clear that that's the way it works, but that is the way it works. Non-accredited investors have to get these long, onerous documents, financials, disclosure about the company. It ends up looking a lot like a registered offering. So now you're writing a 100-page document to bring in one non-accredited investor. And by definition, this is a person that has a net worth less than $1 million excluding their home, so they're probably not going to be a large or significant investor. So the cost-benefit analysis often falls off as soon as you have a non-accredited investor involved. Have to be available for questions. So the idea is you have this exemption. These investors, because of their sophistication and their accredited investor status, are able to ask questions of the company. So they need to be able to have an interaction and provide their own questions. Furthermore, on non-accredited investors, not only do you have this information requirement, but they have to have knowledge and experience in business matters. So you have kind of an extra test there when you have non-accredited investors. The accredited investors are assumed to have this knowledge and experience, but the non-accredited investors aren't. So you have an extra layer of burden there. And you can see here there are non-accredited investors only in about 11% of the 506 offerings from 2009 between 2009 and 2012. So very few of these offerings offer stock to non-accredited investors.
Do they also have to, if you do non-accredited investors, you cannot do solicitation, right?
You can't do, for a 506B, which is the old 506, what everybody talks about, no general solicitation at all.
But can you do it with non-accredited investors under 506C?
506C,
If
you
unaccredited.
can do a general solicitation.
With unaccredited investors also?
No, it has to be accredited investors. That's one of the requirements
So
of 506C.
that's another reason not to do it.
Not to do 506C or not to do 506C?
Not digital.
Not to do unaccredited investors in
Right.
506C.
Yes,
It's not
well-
only extra work, it's also no
506C,
solicitation.
it will take away your exemption. I mean,
Ah.
if you bring in non-accredited investors into a 506C, you're going to lose your exemption. You can't. So
I mean, you
this
do
is talking about 506B.
506B with,
506B,
you don't,
506B, you can have non-accredited investors, but
you
you
can't,
still can't generally
you
solicit.
cannot, okay.
And if you bring in the non-accredited investors into a 506B, now you've heightened your information requirements, usually to a point that's no longer economically feasible. Benefits, though, of 506B, we're still on B, we'll move to C in a second. The 506B, you have an unlimited offering amount, which is great. You can raise as much money as you can negotiate. You don't have any specifically required disclosures. There's usually going to be disclosures that are advisable. You'll talk to your lawyer and they'll say, hey, you still want to get paperwork in front of the investors to protect you in the event of a lawsuit later. And remember, with all these security offerings, I haven't covered it yet, but there's an anti-fraud requirement. You still can't commit fraud. You still can't mislead the investors. So regardless of whether you are required to provide them paperwork or not, and you have an exemption, Still very advisable to give them information and details about the company in a written format to document that you haven't committed fraud and you haven't misstated things. 506B preempts the state law, which is great because you do one set of compliance, you comply federally, you don't have to worry about also complying with the state disclosure requirements or whatever other things are required under state laws. You file a Form D with the SEC. It's a very short form, easy to fill out. Notifies the SEC that this offering has happened. And then you usually have to file it in a notice form with the applicable state. And you still have the anti-fraud requirement and other provisions of federal securities law. You can't mislead people. 506C, this is the new part of 506 that came out. Again, no limit on the offering amount, no state review. Restricted securities, which means these securities, once they're in the hands of investors, cannot freely trade. You still have to file a Form D. Some states are requiring a advanced filing of the Form D in a 506C offering, so we're starting to see that pop up in a few states. They want typically you do your Form D after the offering, but a handful of states have now said that you need to file that Form D prior to offering in their state. And you still have the anti-fraud and other general requirements in all securities offering. So 506C, now you have general solicitation. So a lot of people are very excited about 506C because you can now publicize that you're making an offer. Has to be only accredited investors. So looking at the pool here, the SEC estimates there's 8.7 million U.S. households that are accredited investors. So you have a large market. About 7.4% of households may qualify as accredited investors. And these are obviously going to be your most wealthy people because they're meeting some of this financial criteria to be an accredited investor. So when you move to the 506C world, the accredited investor test changes a little bit. So 506B, you ask somebody, are you an accredited investor? And then usually advisably you'll get a form from them where they sign and say, yes, I'm an accredited investor. I have $1 million net worth excluding my home. I have a $200,000 income. They self-verify. 506C takes a slightly different tactic, puts a little more burden on the company or the person offering the securities and says they have to take reasonable steps to verify that the investor is an accredited investor. So you look at the nature of the purchaser, what do you know about them, what's your pre-existing relationship, and then there's a group of safe harbors in the 506C regs where if the people meet this certain criteria, the SEC will deem them to be accredited investors and the company will be safe. So you can get a statement from a broker that says, yes, this person's an accredited investor. I know they have over $1 million excluding their home. You can get it from the accountants and various other sources, and if you comply with those, then you've got a safety. But the onus is now switched between a 506B and a 506C. The onus is on the issuer to take reasonable steps to verify that that person is an accredited investor. And again, conditional exemptions. You don't meet a condition, you lose your exemption, and it's the entire exemption for the whole offering. So here's some of the ways of verifying. Look at the bank statements, look at their income, look at the prior dealings with the company. And the SEC has listed some of these out. But it's a non-exclusive list. You can use any other reasonable step, whatever that means, to verify somebody's an accredited investor. And the SEC has said that the company is not responsible if the steps were reasonable and the investor lies or is not accredited but says they're accredited and there are reasonable steps taken. It's not the company's fault. So at least you have that fallback. As long as you're taking reasonable steps, have a reasonable procedure, you'll be protected. So it should be simpler. People think this may be the real crowdfunding. So everybody's been talking about crowdfunding, but this may be the way that people can do a lot of the crowdfunding type activity and get SEC exemptions for their offering. And we're going to talk about crowdfunding in a second, but it's still not live yet. We're still waiting for things to happen there. So 506C is a way you go out, interface with investors, tell the world what you're doing. So as long as you meet those conditions, you can go out there and publicize your offering, put it on your webpage. Crowdfunding. This is the part of the Jobs Act that came out several years ago that everybody was...
Well, the platforms are using 506C and the real estate is using 506C.
Yeah, people are using 506. It's live.
Well,
I mean,
the last 2 years.
right. Yeah, we don't, we're still waiting to see statistically what percentage go 506B versus 506C, but yeah, that's the real deal. We think that's where, at least now, where we are regulation-wide, that's probably the one that's getting the least excitement and least press, but it's the one that's most widely available and fits a lot of circumstances. So it's probably been underreported. So Crowdfunding Act came out several years ago to great fanfare. Congress acted very swiftly and quickly to bring out the Jobs Act, and the lead part of the Jobs Act was crowdfunding. And crowdfunding really has two pieces. I always like to stop and break it apart. Crowdfunding is a word that was being used before the Jobs Act came out and before this came out. And people were using it for product-based crowdfunding. So the term crowdfunding has been out there for a while. People have been using it. Now they apply it to a different scenario, which is selling equity or equity raises. So two completely different things from a securities regulatory standpoint, from a financing standpoint, between a product-based crowdfunding, going out to a market saying, I'm going to be making this product, do you want to buy it, versus equity crowdfunding. But they've used the same word for both, so it's caused a lot of confusion in the world. So people are like, is crowdfunding legal? Well, which crowdfunding are you talking about? That's the first question. You know? And I have a smirk over here. So yeah, you've seen this before. And you have to break it down. Are you products or are you securities? Securities crowdfunding is still not approved at the federal level. We see a little bit of it at the state level. We'll talk about that in a minute. So crowdfunding here, these are the proposed regs. The Congress laid it out and told the SEC what they had to do. And it's kind of gone into the SEC world of, being proposed and revised and proposed and revised, but still has not been adopted by the SEC. So it allows basically transactions through a funding portal. So this new system is being set up where you'll have an intermediary or a funding portal. This is where the investors will go to look at potential investments. So as long as you're a qualified company, so you're not a non-U.S. company, you're not disqualified, and you're not a certain investment company, you're eligible to sign up with a portal. And then you can go out and interface with these potential investors and raise money. The big thing that's missing here is the final SEC regs that kind of set up the details of how the portals work and how do people interface with the portals and what requirements are there. So, the SEC's proposed various financial disclosures, which we still don't have all the details. At what level do you need to have audited financials? At what point do you need annual financial reports? And then there's no general solicitation here. You go onto the portal. The portal is your advertising mechanism. So as these portals get set up, they will have their subscribers, and that is how you'll interface with your investors rather than going out and putting an ad on the internet or telling a lot of people. You have to go through that requirement. So here's the SEC rules on financial statements. If it's under $100,000, you can be reviewed by your principal executive officer. Start getting that intermediate range, $100,000 to $500,000 capital raise, independent public accountant. And then if you get over $500,000, you're looking at an audit. So a lot of people are questioning whether these trigger levels are correct and how much this burden is this going to put on the company. To go out and do a $100,000 offering and have to get a review by an independent public accountant may not be cost beneficial. Same with a $500,000 offering and an audit. So SEC's position is these trigger levels are at the right point. They think that they've hit the magic numbers, not too burdensome. But the SEC has estimated that it could cost $29,000 to get an audit done. That's about 6% of your proceeds if you do a $500,000 offering. So, question whether you think that's cost beneficial to spend 6% of your offering on your account. That's before you pay the lawyers, pay the funding portals, or any of your other expenses of getting out there. The intermediaries or these portals, they have to register with the SEC, be part of a National Securities Association, provide information to the investors about the risks, etc., and then take measures to reduce fraud. So we're putting a lot of onus on the portals. So we don't know what that's going to look like from an expense profile and what it's going to take for the portals to comply, but the SEC shifted a lot of the work over to another category of people.
To be a portal, would it be easier to become a broker dealer?
Yeah, that's something to look at. Yeah, I mean, broker dealer is not an easy avenue to go. I mean, there's a lot of regulations around being a broker dealer, so that's not going to be an easy way to set yourself up as a portal either.
If you want a portal, would it be easier if you had like your Series 7, Series 66?
Yeah, I mean, those are going to be foundational items. You're going to need your securities licenses. I mean, that's just a starting point of this.
To develop the portal?
To develop a portal, yes. That's
okay.
just a starting point to develop.
So, I mean, to have that, then does that mean that you need to be connected with a broker like a JP Morgan or whoever, being in fact to be
you won't necessarily have to be associated with somebody of that size, but you're going to have to.
Yeah.
You know, you've got to register with the SEC. You've got to be a member of a national securities association, which means you're going to have to have your licenses and go out and get affiliated with them. That's usually not a cheap expense. They have audit requirements and other things in order to become affiliated with a national
So
securities.
you do an approximation or something?
I've had broker dealers tell me that their compliance costs on the low end are $200,000 a year to be a broker.
$200,000 a year?
Yeah, just for ongoing audits, record keeping, compliance costs, low end of $200,000 a year, and it goes up from there. So it's not an easy thing to do. I mean, you're in a heavily regulated area with audits, record keeping requirements that are very onerous and expensive. And you have to have independent audits, and other people come in and look at all these various records that you're keeping in a very detailed fashion. So it's not inexpensive to become a broker dealer.
What they do right now is, I know I talk to a lot of platforms, they actually partner with broker dealers.
Yeah, partnering with the broker.
So because some of them try to become one, but it takes years, it's a very expensive process, or they partner up with one. And
it's better to probably
Yeah,
partner.
that may be your most cost-effective way of doing it, right? Is
Okay.
partner with an existing broker dealer.
But you have to do it, yeah.
And that broker dealer, though, is going to be very careful about partnering because their license is hanging on it. So they're going to kind of move those record-keeping requirements down to you, right? So they got to have records. If they're going to partner with you, to work with you, they're going to make sure that you're keeping your books and records in a good fashion because they don't want to get a whipsaw effect. They don't want you to do something wrong that's going to impact their status.
There are businesses that are forming as broker dealers for equity crowdfunding sites.
Yeah.
That are positioning themselves to do that.
Right. Yes.
And escrow.
Right.
All escrow.
Yeah.
That's all tied together.
Yeah, that's out there, and it's a growing. And what's been interesting is there's been a lot of interest in crowdfunding. Everybody's trying to position for it, but the final regs aren't there, and nobody's kind of been able to finalize and get it going. But yes, there's a lot of positioning going on there. There's broker dealers being formed for these purposes. There's portals that are kind of in the ready stage, waiting to go live when this happens. Everybody's kind of positioned. Everybody's jockeyed up as best they can, and waiting for something to happen. So here's some portal requirements. They can't be providing. They're basically just an intermediary to allow the investors to interface with the potential investments. They're not pushing certain investments. They're not giving advice to the people that are signing up for the portal. People sign up for the portal. They come in. They look around at the various investments and decide what they buy. The portal can't pay its employees to sell more stock. It's not about moving volume. It's about just providing an access point between the investors.
So I'm sorry. So there'll be regulations with trying to get subscribers onto your portal.
You'll be able to get subscribers onto your portal. You can't move a particular investment. So if XYZ company signs up with the portal, the people that work at the portal or the portal itself can't promote the stock of XYZ company.
They can just bring them
They just
onto
put
the
XYZ.
portal.
They just put it on a list. Yeah.
Okay.
And so there can't be these additional activities to move more of the stock.
Unless they're registered as an investment advisor, right? And that's a different type of
Investment
registration.
advisor, separate regulation, but the portal itself can't do it. There might be investment advisors attached to the portal that could potentially theoretically do it. The portal itself can't be doing that.
Okay.
So you have to be. It's going to be one of these regulated dances where you probably have affiliates that are doing different pieces of it, but the portal itself can't be the one that's promoting a particular stock. Again, it's just more of the detail here, but intermediaries have to implement systems to comply, figure out how, and they have a set of requirements they have to figure out how. And here's an estimate by the SEC of how much they think it would cost to sort of set up what you need to do for a portal. $417,000 first year, $90,000 a year after that. But these are SEC estimates, which are rarely accurate. So you have to figure out what it actually costs in the real world to do something like this.
But that's federal, so that would be being able to receive money globally, right?
Yes. Well, it would the funding portal, if you set it up and comply, the portal would then be allowed to offer this. Would be able to list securities on there for purchase by investors, but it's federal level exemption. So yeah, so anything moving through that portal should be exempt from federal regulation. If you have international investors, you may have regulations in their home country. You have to worry about and comply with that. But as far as you have U.S. investors, you should be open.
To the extent that we see this crowd sale to consumers or
Yep.
the general public come about, do you think we're going to start seeing like state-by-state regulation like you have with money transmitters?
Yeah. Well, we'll talk a little bit about that now because we're starting to see some state regulations like interstate crowdfunding. But yeah, the way the Crowdfunding Act is set up is that should be a federal level regulation, should preempt the states. We shouldn't have that state level regulation on that.
Which should exist with money transmitters as well.
Right, exactly. But you know, yeah, states are trying to figure out how they fit in there together. I guess we'll have to have a test case or two if the states try to regulate it. We'll see whether the federal courts uphold it or not. You know, we occasionally see a state that doesn't necessarily comply with exactly the way the federal laws would. Again, that becomes a huge interesting constitutional law analysis of when Congress says something and then the SEC, pursuant to its authority under that, says something. You know, to what extent does that override the states? And all bets are off because that's just a constitutional law analysis. The details of where the federal overlay ends and where the state overlay begins. You know, it can go to court. So we may see some early cases. The first people doing this may be the test cases. So another option, so the SEC has drug its feet on doing the crowdfunding regulation. So we've seen a few states that have started allowing crowdfunding within their state. You can see a list here of the states that have done it. Mostly smaller market states, although we have a Texas, Maryland, where there's a good deal of wealth. Georgia, Atlanta, some large cities. So mostly smaller states, but we do have some concentrations of wealth that are allowing intrastate crowdfunding. So in these states, you can have a company in that state offer securities to people that live within that state. So we're outside the federal system, we're now within a particular state. So you have to make all your investors be from that state, but a handful of these states are allowing crowdfunding within their borders. This is just kind of a very broad overview of what we see in the state regs. Offering limits has to be exclusively within the state. One issue we've seen is some states even say, if you put it on social media, you have to make sure it only hits people in that state. So I don't know how you set your Twitter account up or your Facebook up so you only communicate with people in one particular state.
China has apps for doing that.
Yes, yeah. So you have to hire somebody in China with their securities and procedures, and get them to set up that compliance. Yeah. So it's one of the things where a lot of stuff still in very early stages has practicality kinks in it.
So how does this affect most companies registered in Delaware? And then
Well, most of the exemptions require you to be registered in that particular state, so you're not going to be able to take advantage of a Delaware registration. So
it's where you're primarily incorporated.
Most states, the statistics vary, but a lot of companies are incorporated in Delaware. So with these intrastate offerings, you're going to have to pick a different state of incorporation. I imagine we can see companies moving to a particular state to get advantages of doing it in that particular market. It takes away Delaware, which what happens is people often form early in Delaware in anticipation of bringing in a VC round or a private equity round later. This is going to change that timing. It may need some additional costs because you're going to file in one state, raise your first round of investors there, and then if you grow to a certain size, you're going to reincorporate.
If you were a majority shareholder of a subsidiary that incorporated in said state, would that be okay? If you were a Delaware incorporated company that had a subsidiary that you were a majority shareholder in,
yeah.
So you just incorporate a baby in Texas, would then you be able to sell to Texas?
It's an interesting idea. Possibly, yes. but then the problem is, what are the investors buying into? The investors are then buying into the baby entity, not the parent. So the business and operations of a subsidiary would have to stand on its own.
Okay.
You know, so it'd have to be a worthwhile investment, or else nobody's going to buy it.
That's
Yeah. So it just you're going to have to separate certain operations off and put it in there. Regulation A. So we're going to talk about Regulation A, which is the old guard, and then A+ is the one that's been getting all the press. Regulation A has been very scarcely used. It's essentially a system where you can do a mini registered offering. So you prepare an offering circular, you file it with whichever states you're doing the offering in, and the states comment on it. Once it's final, you have all the state comments in it, then you can use it to advertise in those approved states, assuming state law allows you to do so. So you prepare a document, you run it through your state securities regulator, you get it ready, and then you can advertise it in that state. So I've seen very limited activity on Reg A over the years, though. Here's some of the general characteristics. Simpler financial statements, no limits on investors, but the big problem with Reg A has been the amount, which is $5 million. So people have long been, Reg A has been out there. We've seen a few Reg A deals here and there over the years, but with a $5 million limit, by the time you do the state law compliance and prepare an offering circular, most people say, never mind, let me go back to 506 under Reg D. I don't want to do all this state law compliance. I don't want to prepare these documents. So for several years now, people have been looking to improve or overhaul Reg A and to bring in something else that would work for investors, which is where Reg A plus comes in.
Reg A was for non-accredited.
Huh?
Reg A was for non-accredited?
Yeah, Reg A, you can do non-accredited, but you have to sort of go through that state registration process and prepare it. The idea being that the state regulators have taken a pass at the documents, they've looked at it, they've approved it, so they've built in whatever information or protection they think the investors need to be informed. Much like the SEC registration process. Once you've registered with the SEC, that process goes back and forth between the company and the SEC, usually several rounds. By the time the SEC says, yes, you can register it, the idea being the SEC has negotiated for and built the information in that they think the investors need. So Reg A Plus has two tiers to it. We'll talk about those tiers here shortly, but basically you got a $20 million tier on the low end, tier 1. $50 million is the second tier. Final rules were done on March 25th, gets published in the Federal Register, then we wait 60 days. So very soon Reg A Plus will be live. So tier 1, up to $20 million, tier 2, up to $50 million. There's a limitation on how much the insiders can sell upon the registration. So the idea being you can't, so if you're the officers, directors, control parties of the company, you can't really use a Reg A Plus to dump all your stock to investors. You have to bring fresh capital in. So there's limits on the dollar amount that the insiders can take. You file the offering statements with the SEC, has certain basic information in it about your company. Looks like it's basically a light registration statement, not the same thing you would see for a public company, but definitely a lot of information about the company. Allows you to go out and start doing your solicitation early in the process. Your Reg A Plus securities are not restricted, so they can be sold again. So you bring your investors in, they have an additional liquidity. A lot of the other exemptions and requirements, the stock stays restricted. The investors can't freely sell it. They have to comply with securities laws to sell that on to somebody else. And here's sort of an overview of the difference between the two tiers. So tier 1, lower tier, up to $20 million. Don't necessarily need an audited financial statement unless you already have an audit done. You're going to do a report 30 days after the offering to your investors. Don't have a limitation on your investments, but you're subject to state review. So in this low tier, whichever state your investors in, they're going to get a pass at these documents. Tier 2, got a requirement for audited financial statements. And then you have these ongoing requirements, semi-annual reports and current reports. As events happen, you're going to have to report that to your investors. And you have a limitation on the amount that non-accredited investors come in. So you have the availability of non-accredited investors with a tier 2, but they can't put in a lot of money. no more than 10% of their annual net income or net worth. No state review on tier 2, so that's a nice feature. You don't have to worry about complying at the state level. So you need to figure out which of these 2 bullets you're going to bite, whether you want to do the state review or whether you want to go with the higher ongoing disclosure requirements of a tier 2.
So, question about state review. Do
Yeah.
you need just a state that your company is registered at, or you gotta go every single 50
State
states?
that you're offering.
And what
So where
investors are from a different state?
That's the states you're registering in. The states where generally.
Let's say you're in New York and your investor is from California, so you're
Right.
actually in New York and California, or just New York?
New York and California.
So every
Yeah.
single state the investors in.
Every state the investors in.
Okay, so-
Plus possibly your home state of registration, depending on how that state set up their regulatory scheme. So you're looking at possibly doing multiple states, and then they have a system, Reg A, and people that have done Reg A, you can get a coordinated review. So you get all these various states, and you try to get them to work together, although they don't necessarily play nice with each other. But so there's people who've done Reg A's that have hit 4 or 5 states, and you get these 4 or 5 states all commenting on it simultaneously. And the states try to make that process work smoothly, but they don't always necessarily agree, or they don't always necessarily turn the comments and get the feedback back to the company on a timely basis. So the more states you go in, the more balls you got in the air, the more people you got to keep coordinated.
Yeah, so what would be the cost for filing all these states?
Hard to say without knowing. I mean, it really depends on how your documents go out to the state, and then how aggressive the states are. If they get the investment, it makes sense. You have good disclosure documents. You may get through the review process fairly quickly. If the state doesn't like your company for some reason, because they're almost passing on the merits when they're doing this. They're doing a merit review. It's just a worthwhile investment. They're really going deep on this, beyond just checking a box. That you talk about everything you're supposed to talk about, because they know the possibility of non-accredited investors is out there. So this can be expensive. You want to minimize the number of states. The more states you get, the more complication you get, because they all have to agree with each other at the end.
What are the rules for determining residency of your investors? It's similar to tax rules as well? Or?
Yeah, it's which state are they resident in, and that's another great part of constitutional law. Figuring out where somebody's resident or actually domicile becomes the more important thing. Where's your legal home at?
Is that something else that investors sometimes play with to maybe?
Yeah, you have to be careful about it. It's interesting. The SEC went after some people recently because they registered in. There was an investment advisor, and they listed their home state as being Wyoming, but the guy lived in Fort Collins, Colorado. I don't know if you're familiar with that area, but it's about an hour and a half drive, hour and a half. So this guy was living in Fort Collins, keeping an office in Wyoming over the state line. And they registered with the SEC saying their office was in Wyoming and they complied with Wyoming law. But the SEC figured out the guy lived in Colorado and was doing a lot of work from home in Colorado and reclassified it. So you have to be careful if your investors are playing with their state of residence, because if you know that they're doing it, it could blow the offering.
What happens, let's say, if there's somebody who legitimately travels just around a lot and has to work in some months in California, some months in New York, some months in Texas, some months in Florida,
Right.
literally everywhere.
Yeah, well, if they're literally everywhere and you don't know where they are and they tell you what their domicile is, I would guess you're probably okay. But it has to be reasonable. It has to be a reason for that. They can't be spending 1 day a year in New York and saying their domicile in New York unless there's some other reason. So these court cases on domicile look at where are your significant conditions, where were you raised, where do you keep your household, where do you go to church, where are your vehicles registered. I mean, it's just a huge argument, and so you really have to go through a lot of analysis, and there's no clear answer. So, but you as the company, when you have an investor coming in, you got to make sure it's reasonable. You can't turn your head away if you know somebody's not in California. They're spending 1 day a year in California. California is probably not their domicile.
But so as a company, would you then want to turn away some investors who are in these kind of tricky situations to avoid the risk?
Possibly, yes. I mean, it's a risk analysis. It's one of the things you're going to look at. If I was a company and I had a tricky investor and they weren't significant, I might turn away to avoid the risk. I'm going to do an analysis. Is this worth the risk to my offering for this investor that's in 30 states or whatever, or moving around throughout the country? It's something to think about.
How's it going? I just had a quick question. That's probably more in depth.
Yeah.
After the financial crisis of 2008, the SEC kind of incentivized people flagging shadow banking, insider trading types of frauds to get whistleblower claims to,
Right.
you know, reap the reward from that to fund other types of ventures.
Yeah.
And I was wondering, you know, more along the lines of his question, domicile. If someone's in, you know, SAC Capital, which just recently changed their name to Point72 Asset Management, they're in Connecticut and they have an office in New York.
Yeah.
Obviously, the jurisdictional venue kind of puts everything in a bind.
Right.
But you know, taking that one step further, what happens if the SEC is using your case or using a potential whistleblower claim as leverage to win favorable judgments in the amount of billions of dollars, and you kind of get caught in a bind, but you're on the other end executing energy deals in the hundreds of millions of dollars and the billions of dollars, and
Yeah.
they try to play both sides, but they don't get the way that they want.
Right.
And
Well, that's just part
it's-
of what happens in these things, unfortunately. I mean, you got to watch out for that because the regulators are out.
Oh no! Obviously, when you're have your company or energy company or whatever you
Right.
do, and there are different types of these situations going on, the regulators try to play both sides.
Yeah.
So they try to find someone that's not doing as well as they could be, respective of ongoing criminality in other sectors,
Yes.
and then use that person's position to execute the type of judgments in the billions of dollars, whatever, insider trading.
Right.
But then that, you know, if that person's doing well,
Yeah.
they usually try to circumvent that, respective of other types of wire fraud and other types of,
Right.
you know,
Yeah.
tertiary fraud that
Right.
there was just a big NSA judgment against these types of corporations that are using these types of, you know,
Yeah. We can,
types of
we can
wire
visit-
fraud solutions. I mean, it's
Right.
kind of a complicated issue,
It's very
but
complicated. We can,
you know what I mean?
we can visit on it a little more after the presentation.
Oh,
but
okay.
It's just
All right, cool.
it's you've got to watch that. The security regulators,
Yeah.
they're trying to set precedent. They're trying to say, hey,
'Cause there's
we're,
a
we're
big-
clamping down.
Big
and-
case, I forget the case with Scores,
Right.
and they're using, you know, the SEC was using them,
Yeah.
you know, to infiltrate the mob, and
Right.
then the other person, the person that was helping them out, didn't get what
Well,
they
they often-
wanted, and
And it
Yeah,
brings
yeah.
up a broader point. Security regulators often like to find somebody on the inside or somebody that can inform them, and they'll give that
but
person.
they kind
If
of
they know something bad happened, they'll give somebody a free pass. Or,
they try
or
to,
help
or
them.
they say that
in order
and then
to-
stab them in the back, or try
They
to
have, yes.
negotiate a position out of that to
Maybe
not.
if you're going in for a discussion with the SEC, bring your white collar lawyer. I mean, it's
Yeah,
really
yeah,
the-
yeah.
you know, if you're going to go meet with the SEC or meet with a state securities regulator,
Yeah, we'll
bring
definitely
a
talk
white
after.
collar expert. I'm going to try to wrap up two more slides, and then I'll take your question.
All right.
And I'm also going to be here for Q&A afterwards because I think we're hitting the time limit here. Here's an overview just of everything. So you can see, here's your general overview of which one you might want to do. You can see some are accredited and non-accredited, limitations on amounts, and whether you can do a general solicitation or not. So that's your overview of the major exemptions we talked about today.
So just touching on the 506C point.
Yep.
Going out to, let's say, to VCs or to angel investors or anybody and just saying that, hey, you should invest in my company. Does that count as a general solicitation? So under C, or just that's non-general, so under the
Well, C, you can do a general
Well, that's what
solicitation, so you don't need to worry about that.
Exactly.
But B, yes, going out to people, telling people they should invest in your company if you don't have a pre-existing relationship with them.
And what and is there classifications as to what constitutes a pre-existing relationship?
There's a
Or
lot of
just
tricky,
an
there are a lot of
email
tricky
one time?
case law, and if you've known somebody for an extended period of time and have some relationship other than just selling your investment to them, then you may have a pre-existing relationship. You can't just approach somebody known for a couple of days and then ask them to buy your investment. It's a very
Under 506B.
Yeah.
So under 506C, that's
506
Totally
you
fine.
can do a general solicitation. So you can just post a billboard out there saying
So-
buy my stock.
so as a company, say going out to venture capitalists, 506, and you know you don't want any uncredited
Right.
investors, just
Yeah.
506C, and you're safe for
Yep,
everything.
that's a better way to do it. Yep, in that circumstance. All right, so just consult somebody early on, set your plan, figure out which of those various exemptions is best for you, and then just lay your plan out accordingly. So, I did have a question back here.
So you have John or Jane Doe who's selling his or her widget on either Kickstarter, Indiegogo, etc. The widget's a physical product, not a service. Okay. What infrastructure are they falling under?
If they're just selling a product, then you're outside of securities law. That's not a security. It's
Okay,
a
which
product.
begs the next question. We bring up the UCC into this too somehow?
Yeah, I mean, you've got general commercial law and product law, which are completely outside of this. I mean, you can't. It has to be a safe product, right? There's going to be state regulation, whatever this physical product is. You know, it has to meet flame retardant rules or whatever else might apply to it. It has to be safe, and then there's usually consumer protection laws out there. You know, misrepresentations, deceptive trade practices. We've got a whole other set of regulations, which another lawyer can come in here and probably spend an hour talking to you about that on. But you know, it's a whole different regulatory scheme. But you're outside the securities law scheme for your sales of your physical product, your actual business operation. This is dealing with bringing money into your business, not operating your business.
Can you talk a little bit about the differences between crowdfunding debt versus equity, and whether convertible notes fit into which category?
Yeah, the question is it a security? And we didn't really talk much about debt versus equity, but generally debt's going to be a security, unless it's a very short-term debt obligation. And there's some case law out there that says that's not a security. But debt can be a security, convertible can be security, options are securities, warrants are securities. So everything kind of falls under a category of securities, unless it's a short-term note or it's a product sale. So yeah, any debt or equity in the company, any investment in a company, anything that's tied to the profits of the company is going to be a security.
So at the beginning you were talking about friends and family and how that there's no exception for that.
Right.
So what is the usual way that people right now, when they say they're doing friends and family, what are they really doing?
Well, they're doing friends and family, but they need to find a securities law exemption. So you're offering to your friends and family. So you want to look at what exemption. It could be a 506. You know, a lot of times people do it under 506. If the friends and family have sufficient wealth, you know, that's easy. Put it under 506, get it done with. If they don't have sufficient wealth, they're not accredited, and that becomes a much harder issue because what we find is the investors say it costs more to comply with the securities law to bring in a non-accredited investor than their dollars are worth. So, yeah. Any other questions? I'll be here for informal questions if anybody's got one. I got one more and then I'm going to wrap up.
So if I buy $1 million in a Reg A offering, for example, where do I sell those securities if I want to liquidate my position?
You can do a placement to another person. I mean, there's different securities law ways, and it gets kind of complicated. But you can sell it on to somebody else. If it's a restricted security, you can do an offering. You just have to make sure that offering complies with security law. So a lot of the same type of analysis is going to happen vis-a-vis the two purchasers within each other. And usually too, if you hold it for a period of time, then it comes to rest, is what they say under securities law. So once that investor buys it without an intent to redistribute it, and then holds it for a period of time, then it comes to rest, and then they can sell it because that's not an offering by the company. You're outside now of the securities law. So, all right, I'll take you as the last question.
Well, when the crowdfunding, when it goes into effect, end of the year or so, will the major banks, will they be competing, or do you think they'll create like a division?
I would not be surprised. I mean, if these regs come into place, I've got to imagine players big and small are going to want to participate.
But wouldn't they have, I guess, maybe the upper hand being the fact that they have more credibility?
They have a name, they have a brand. It's just like anything else emerging. You're going to have the new players who are going to be innovative, who are going to do it differently, and are going to try to, step outside the box. And then you have existing players that have money and names and resources, and the two of them are going to be competing for turf, and we'll have to see how it plays out. So, Alex, thank you very much. I appreciate it.